Hello, everyone who's joining this webinar. We'll just wait for a minute or so for the room to fill up virtually, and then we'll get going. It's always intriguing to see the number just creep up. I'm imagining everyone filing in. Well, should we get going? So thanks everyone for joining us on the eve of another lockdown. I think I can still say Happy New Year despite that. And thanks for joining us this evening for this event on the future of environmental assessment. It's just so topical. The transition period for Brexit, of course, ended on New Year's Eve, and the different forms of environmental assessment that play such a significant role in our planning system, i.e. strategic environmental assessment, environmental impact assessment, and habitats regulation assessment are all, of course, derived from EU law. And so with the promise of the reforms in the Planning for the Future white paper, and with the UK now having greater control over how we legislate, we can expect changes to come forward in 2021. In fact, I've got no doubt that the government is keen to demonstrate the divergence possibilities that are now unlocked. So at the start of the year, what better time to ask ourselves, well, how has environmental assessment worked and how could it be improved? And I'll come back to this at the end, but I'm hoping that we can collate the output from this event, including suggestions that you may all subsequently have into a submission to DEFRA and MHCLG, ideally ahead of publication of the proposals that we're waiting for from DEFRA. So I really am joined by a brilliant panel. First of all, from Keating Chambers, Charlie and his Christmas tree. Hello, Charlie. Apart from his role as a practicing barrister, he's an independent committee member of the JNCC, statutory advisor to the government on nature conservation. And this area of the law has been a constant sort of theme in your work in the courts. So welcome, Charlie. And then from Town Legal, our consultant, Steve Quartermain, formerly Chief Planner to the government, of course, and then Duncan Field and Sophia Islam. So just very briefly on housekeeping for the event, you'll be pleased to hear know that we, of course, can't see you, we can't hear you, but you can interact with us via the chat function or by raising questions with us via the Q&A function. And we'll try to weave in responses to those questions as far as possible as we go. Since we set up this event, we had the excitement just before Christmas of the UK-EU Trade and Cooperation Agreement. A no-deal Brexit was averted, hooray. The agreement sets out some basic environmental principles that we mustn't derogate from as a country, with, it's fair to say, fairly weak legal mechanisms if we do derogate. Referral by either party to on a non-binding basis to a panel of experts. Although in practice, I suspect that differences would be more likely to play out in negotiations as to tariffs and the 5-yearly review of the operation of the agreement. The environmental principles are the same as those in the Environment Bill, but there is much to be fleshed out. We're currently in a hiatus period, which was anticipated by nobody, the UK government included, in that until the Environment Bill becomes law and the Office for Environmental Protection is up and running, there's no recourse for anyone if there's a breach by the UK government of environmental principles, which before the 1st of January would have led to a complaint to the European Commission or referral by our courts to the European Court of Justice. Each of the panel is going to tackle an aspect of this subject in the hope that we'll all end up with a good understanding of not just where we currently are, but where we might want to get to. Steve, as the non-lawyer on the panel, I'm looking for you to intervene if we get too embroiled in jargon. I really want to start with the building blocks of this complicated subject. So first of all, I was going to turn to Sophia to kick us off with saying something about the role that environmental assessment plays in the planning system at the moment.
Yeah, thanks, Simon. So I'll just take you on a quick whistle-stop tour of the 3 types of environmental assessments that are required by EU directives, which have been transposed into our domestic planning process. So as you've mentioned, strategic environmental assessment, the purpose of that is to ensure that environmental considerations are taken into account at the plan making stage. The EU's 2001 SEA directive is given effect in England by the Environmental Assessment of Plans and Programmes Regulations 2004, which require that an assessment of the effect on the environment of any plans or programmes, which I'll just refer to as plans, if they are being prepared or adopted by a public authority at national, regional or local level, and if they're required by legislative, regulatory or administrative provisions. In the planning context, SEA is mandatory for any plans which set the framework for future development consents of projects and are likely to have significant environmental effects. The assessment itself then involves preparing an environmental report on the likely significant effects of the draft plan when judged against reasonable alternatives, carrying out a consultation on the draft plan and the environmental report, and then showing how the report and the results of the consultation have been taken into account when the plan's adopted. SEA is often incorporated into the sustainability appraisal process required for authorities making local plans, but it can also be required for neighbourhood plans and supplementary planning documents. So then we have environmental impact assessments, which are there to ensure that environmental considerations are taken into account at the development consent stage by spelling out for decision makers the effect on the environment of proposed major developments. The 1985 EIA directive, currently given effect in England by the 2017 EIA regulations, requires an assessment of projects above certain thresholds, with some projects always requiring an EIA and some only requiring one if they're likely to cause significant effects on the environment. So the EIA requirements only currently apply to about 1 in every 1,000 planning applications, but these do tend to be the largest developments. If an EIA is required, the applicant must produce a detailed environmental statement setting out what the proposals will mean for the natural environment, which can often account for about 75% of the paperwork involved in the application. On the local planning authority side, they can be required to screen schemes to determine whether an EIA is required, and if it is, to agree the scope of the environmental statement. And they then have to take the statement into account when determining the application. And then the third type of assessment is Habitats Regulations Assessment. And the 1992 Habitats Directive, which is currently given effect by the Conservation of Habitats and Species Regulations 2017, requires an assessment of both plans and projects if they're likely to have significant effects on areas or species of ecological importance, which are protected by the EU's Birds and Habitats Directives. And this assessment is known as an appropriate assessment because its scope and content depends on the nature, location and scale of both the proposed plan or project and the relevant habitat site. Those plans and projects may then only be approved if no adverse effects on the integrity of the habitat site are found, which is a slightly higher bar than just having to take the assessment into account. And where an adverse effect on the site's integrity can't be ruled out and there are no alternative solutions, the plan or project can only proceed if there's an overriding public interest to do so and compensatory measures can be secured. So hopefully that's set the scene.
Well, no, thanks, Sophia. I think we did need to start with that, and that was very clear. Thank you. So, Steve, you know, from your perspective as a planner, you know, what problems have you seen with the current approach to environmental assessment?
Thank you, Simon. And while listening to Sophia's introduction, I should come back to some of the things that she's mentioned, I hope. But I want to start by sort of just reminding people that, I mean, EIAs and SEAs, I mean, they're a good thing. I mean, it's important to have regard to the consequences of projects and the consequences of plans. People need to understand what the environmental impacts are, and they need to know whether things are being delivered are going to be sustainable and what the sort of reasonable alternatives might be. So I want to start by reminding everybody that this is a good thing, and it should be in the DNA of all decision makers in the planning system, whether planners or developers. It should be part and parcel of the process. So why do I think that the present system isn't working? What sort of goes wrong? Well, there's several things I want to highlight, although I don't want to make this appear like an exclusive list, and I'm sure that many people on the event will have their own views, and some of the stuff I'm going to raise will probably be well known. But I want to start with the actual regulations themselves. I mean, the regulations as written do give the opportunity for challenge and dispute. I mean, it allows for interpretation, although as with all regulations, they start off with an interpretation at the head of the header. But things such as, exactly what are the significant issues, what are significant effects, what is scoped in and what's scoped out, what are reasonable alternatives. I mean, all these things allow people to, you could argue, game the process. And to be honest, as you mentioned, the only non-lawyer on the panel, I can say, well, it's good work for the lawyers, isn't it? I mean, there's plenty of opportunity for the legal profession to take issue with issues such as what is significant. I mean, I say that because I look back at the times when when I was in government and we were writing MPPF, and we used the phrase about relevant policies. I don't think when we wrote that phrase, we ever thought it was going to end up in the High Court. But of course, it does, and people do get challenged. The intention of the regulations are well-intentioned, but the opportunity to revisit the wording of some of the regulations is, I think, that it's important. And it's not only about the regulations, but it's also the way in which they're interpreted and applied. And I think found with looking at how the planning system works, it's not necessarily the legislation or the regulations, but actually how it is used, which gives a rise to the biggest concerns. I think people talk about the system being complicated, they talk about it being time consuming, and they talk about it being expensive. All of the above is true. Other countries have a much simpler system. If you look at some examples from a field, if you go to New South Wales in Australia, they have an approach which basically says everything needs some sort of environmental assessment. And they then have a very clear threshold that everything above this threshold would need to be submitted to what is the state government, and the state government scope it, and it's very clear about what needs to be done. Listening to Sophia, you talk about the screening, the scoping, the sort of the Schedule 1, Schedule 2. Our regulations as written give rise to lots of areas of potential dispute. There's something, and even if something in a Schedule 2 doesn't necessarily mean it's going to have a more detailed EIA process, which in itself can cause delay. And although delay is another area where people often say, well, the problem with the EIA, SEA process, it delays progress. I could argue that coming back to my DNA point, if people thought about some of these things earlier in the process, then some of the delays would be mitigated because you'd have thought about it in the first place. So particularly when it's linked to habitats regulation requirements, if you know there's a species on the site, landowners and developers could start to do some of the surveys beforehand. The number of times I've heard questions about, well, we can't do the surveys until the migratory birds arrive back from South Africa. Well, you knew they were there last year. So there is an issue about how you embrace and how you use the regulations. I think that there is an issue about how the regulations themselves and the EIA approach has given rise to an approach which is seen as separate from the planning process. So there's a whole expertise that's grown up around, whole industry that's grown up around EIA and EIA production, really heavy documents which are produced. And it's no surprising that the public in particular see this as a process which excludes them, leads to lengthy tick boxing process which they don't read and don't understand. And of course, it is much more important than that. As I said, it's critical to good decision-making process. And I suppose that links to perhaps my final point, which is the degree to which people regard the process as independent, and whether or not they trust the data that they've been given. And I suppose I've often heard it said, well, you know, the process is driven by the outcome. So if you want to develop something, then your EIA and your assessment is geared towards making sure that it seems to be satisfactory. Now, of course, that is an accusation which is hard to dispute. The facts, I don't think, support it. It is supposed to be an independent, objective assessment of the impacts and the assessment. But from a public point of view, I think they find it quite hard to engage in the current process in a way which is the ambition is for the planning process to be open and transparent. And the current process doesn't really facilitate that. So I think that, you know, as you said in your opening remarks, Simon, the opportunity there is to look at what sort of system we want going forward. And I think there are opportunities to revisit and review the current process to make it more efficient and more effective.
Okay, that's great, Steve. So, Charlie, what's your perspective?
Thanks, Simon. Well, what I've sought to do for the purpose of today is to really cast my mind back over I guess about 15 years of practicing in these areas and try and distill what are, in my experience, the aspects where environmental assessment has really added value, where has it really made a meaningful difference, and those aspects which need to be carried across and perhaps amplified in any new regime. And also think at the same time about where there's opportunity for improvement. Necessarily, I'm going to be cherry picking due to time constraints. I'm not intending to provide a complete list. And I'll take in turn the three kinds of environmental assessment, SEA, habitats and EIAs. There are different lessons to be learned from each. So dealing first with SEA, and I'll start really with the issue of scope. When is SEA needed and when is it not needed? And in addition to development plan documents, local plans and other DPDs, SEA also applies to some other framework setting plans or programs, some of which aren't subject to independent examination, such as national policy statements and at least on one view of the case law, SPDs, supplementary planning documents. And I think that's been an advantage because it's provided a degree of rigor and objective scrutiny to the process of formulating documents which, without public examination in the same way as you get for a local plan, there otherwise wouldn't be that same objective rigor and analysis. So I think keeping the scope broad in that way would be helpful. But that's not to say that legislation was perfect. The provisions in the SEA directive and the transposing regulations about the circumstances when SEA is and isn't required are not clear, putting it mildly, as you and I know, Simon, because we've been involved in some of the litigation about that. Notably the HS2 case, where the Supreme Court held that the government's strategy on HS2 in the decisions next steps command paper didn't require SEA. So you have a situation where an SPD on a specific site can require SEA, but the command paper for the biggest infrastructure project in the country for nearly a century didn't. That seems a strange outcome. And I think the lesson, if we're looking at how to define future rules, is firstly, don't tie SEA to development plan documents, and that should be wider. But secondly, let's either have a clearer definition, or let's have a list of the kinds of documents that require it, make it more algorithmic, as you say, Steve, which cuts a lot of discretion out of the process. You could say the same about Schedule 1 and Schedule 2 of the EIA, which again is consistent with the theme of the Planning for the Future White Paper. Another alternative would be to have a definition and then a non-binding list of kinds of documents which require SEA, a bit like the FOI Act has about there's a general definition of who is and isn't caught by the FOI Act, and then a list of bodies that definitely are. Now, what are the key things to say? Well, I highlight two respects for SEA. And firstly, the requirement for reasonable alternatives to the plan options to be assessed. Generally speaking, I think this has been for the better. It's required a more rigorous justification for the choice of one option over the other, be it in relation to strategic options or in relation to particular allocations. And it's been of particular value, I think, where plan-making authorities have sought to move the goalposts during the plan process. For example, tacking on numbers to a particular allocation because another allocation that can't provide the numbers, or the numbers have to go up, without properly evaluating the alternative options. That's what was the flaw in the SEAs in the Newmarket case, Forest Heath, and the Hurd cases, that the goalposts were moved during the process without sufficient evaluation. It seems to me their SEA was doing its job, requiring assessment before the horse bolts. Another example is Ashdown Forest, where the Wealdon District Council sought during the local plan examination process to introduce a requirement for SANGs within 7 kilometres of the Ashdown Forest SAC, without considering whether there are alternative ways to avoid impacts on the SAC. Again, something that happened late in the process. So it's a useful safety mechanism. Had SEA applied to the HS2 white paper, it would have required more consideration of the alternative route configurations to the Y, which were given scant consideration. So in all these contexts, and others too, the duty to assess reasonable alternatives would have made a meaningful difference, or did make a meaningful difference. And I think that's something that ought to be preserved. As a matter of practice, not something for, I think, for law, but probably for guidance on any new regime. I think the use of text or commentary in addition to, or sometimes instead of, a scoring sheet approaches with all those pluses and minuses and question marks, I think that's more meaningful than a sort of numerical form of alphabet soup. And I'd welcome some guidance on that. I think one of you is going to talk about word limits as well. And I think that's another area where we could provide greater clarity and greater utility and focus. And finally, avoiding an obstacle course. Really, that's not been so much legislation, but the courts. They've done that in 3 main ways. The Cogent Land case, recently endorsed by the Supreme Court in the Heathrow litigation, makes clear that deficiencies in an EA early on in the process can be cured by steps later in the process. What matters is the end product. Walton and Champion make clear that the courts won't quash a plan for failure to comply with SEA where it's only a technical breach. And the Plan B litigation makes clear that evaluative judgments will rarely be challengeable in the courts. And it would be sensible if the new regime preserved those 3 elements so that SEA serves a meaningful purpose without being an obstacle course. That applies to the other areas too. In terms of habitats, again, starting with scope, I think there's value added in the habitats regime as it currently stands by it applying beyond the situation where EI and SEA applies. The plan or project to which habitats applies is broader than things which require planning permission or DCO. For example, water abstraction. 2 of the big habitats inquiries I've been involved in were concerned water abstraction, where there's no development, but there's a project. And the Acaster case some years ago concerned White Link's introduction of a new ferry class, which would have impacts on the Lymington Estuary, which is a part of a wider European designated site. And it seems to me that any replacement needs to avoid any gaps for processes which may potentially affect important habitats which aren't subject to planning control. I think one thing that could be improved is an over-rigid use of the precautionary principle. I was involved in a case some years ago called Catfield Fen, where long-standing water abstractions for strategically important potato and salad crop production were refused renewal on the basis that the Environment Agency couldn't rule out a very small risk of a very small amount of harm, which was likely to be temporary in any event, but you couldn't rule out it was just about possible it was permanent and going to cause harm. And the inspector wasn't really interested in Europe arguments. Seems to me to make little sense to treat a very small risk of a very small, potentially temporary amount of harm as the same as a high risk of a high level of permanent harm. And whilst the case law suggests you can have regard to proportionality at the Europe stage, Europe seems to be a non-starter unless you're a nationally significant infrastructure project, which is going to cause a huge amount of harm. So you only really get away with causing harm if you're going to cause a lot of it, which doesn't seem to be particularly sensible. I think some greater clarity in the new regime and or some guidance that Europe can be a way where you can justify a small risk of a small amount of harm, even on a relatively localized level scheme. That would be sensible, so we can have a sense of reality in the process. In relation to EIA, finally, I think done properly, the related requirements to firstly avoid salami slicing when defining what the overall project is, And secondly, to assess cumulative or in combination effects to avoid anything slipping the net is probably the single most important valuable aspect of EIA, in my opinion. And whilst there have been few successful challenges on this basis, I think the last two successful challenges are Burridge and Brown, which related to, well, they were 2013 and 2010 respectively. Brown's the Carlisle Airport case, probably the most notable. The case law really only tells part of the story, because in practice, in light of those two cases and some of the earlier European cases, EIAs tend to take a conservative or precautionary approach and err on the side of including rather than excluding cumulative or in combination effects. And certainly for my part, as and when I'm asked to review an environmental statement, pretty much the first thing I do is look at how the project's been defined and look at the cumulative assessment, because that's the probably the biggest vulnerability. But in practice, I think it does its job, and I think it's important for that aspect of EIA to be carried across and possibly amplified. I think more generally, the critical aspects in which EIA performs most usefully are, firstly, when it performs a framework for testing the impacts of major projects. Not, again, borrowing from you, Steve, I don't think it does work when in those cases where EIA operates in a sort of parallel world. So you have an EIA, but then the planning analysis doesn't really engage with the EIA. And secondly, providing a reference point for public consultation and participation. Duncan, I know you're going to speak about public participation, but the Aarhus Convention, when I last checked, there's no intention to withdraw from that. And so any new regime is going to have to give effect to the public participation requirements of Aarhus. And finally, defining what mitigation needs to be tied into the granted planning permission or DCO, and with what trigger points. And that's something which everybody on all sides obtain benefit from testing and understanding what needs to be done and by when. It's relevant to the costings, relevant to viability, as well as the merits. And it's a useful, EIA performs a useful mechanism for doing that. I think they're the main elements that need to be preserved, and they don't require voluminous documents or voluminous appendices. And last thought is, I think in some respects, maybe not all, but in some respects, a greater focus on environmental outcomes rather than changes per se may be helpful. I mean, to take one example, probably the best one is when you're looking at landscape and visual impacts. It seems to me there that it would be more helpful to look at the outcome. What does this development, what's it going to look like in its setting, rather than how does that differ from what was there before? It may be in relation to other kinds of environmental impacts, outcome and change is effectively the same thing. But I think if we do look at the end product, I think that's going to be more helpful. So those are my initial thoughts.
Well, that's really interesting, Charlie, and you've really stimulated some thoughts from delegates as well. And it's interesting to see the themes that are coming through, because just in successive questions, someone's raised the issue of perhaps often authorities are perhaps on the safety first side of requiring an ES in circumstances when possibly one isn't actually required. Then the conundrum of we all want shorter ESs, but we want ESs which are more meaningful in terms of the analysis, and how do we get past the sort of motherhood is good, of course we all want that, to actually deliver that. And then something I'm sure we'll come back to is how do we avoid the duplicative nature of the processes where we have multiple assessments of basically the same development at different stages. But let's move on now back to Sophia to sort of explain how EA has now changed following 31st of December.
Yeah, well, it won't change immediately. So just to explain that, although we officially left the EU on the 31st of January 2020, the withdrawal agreement required the UK to continue applying EU law during the Brexit transition period, which ended on New Year's Eve, as you mentioned. But the government sought to maintain the status quo now after the transition period too, by taking a snapshot of the EU legislation and case law, which was in effect at the start of the transition period, and adding it to our current legal framework. And it's done that by passing a series of statutory instruments which replace references to EU legislation in our domestic laws with references to equivalent retained EU law. But things will probably begin to change in the longer term, again, as you've suggested. While the existing regimes will continue as before for now, the government can provide new regulations as to how the courts should interpret that retained EU law. And it can also amend and repeal the retained EU law going forward, and future changes will likely reflect the domestic political agenda at the time, whether that aligns with the EU's position or not. As Charlie mentioned, though, there are some restraints the government would face in terms of international agreements, such as the Aarhus Convention, which provides that the public has a right to engage in decision-making relating to environmental matters. And there's also the Espoo Convention on environmental impact assessment, which is the basis for the EU's rules, which we'd still have to comply with anyway. And we've also seen in the environmental bill some indication of the sorts of wider environmental principles that the current government intends to adhere to, many of which derive from EU treaties. In the latest version of the Environment Bill, the list was cut from 9 to only 5 principles, with the principle of sustainable development being removed, for example. But of those that remain, examples are the principle of preventative action to avert environmental damage, and the principle that environmental protection should be integrated into the making of policies. Prior to Brexit, though, these principles were directly enforceable in both domestic and EU courts. But going forward, the bill only provides that the government has to issue a policy statement setting out how those principles should be applied and interpreted. And then it only has to have due regard to that policy statement. So the principles will have weaker effect. In terms of what we know about the government's plans for reform for EEA specifically, in July 2020, the Environment Secretary announced that the government would undertake a review of it in the UK and launch a consultation in the autumn of 2020 on changes to the system, but it hasn't done so yet. But the speech indicated that some of the aims of the review could be to consider whether the government could collect data at a national level about things like habitats, flood risk, air quality, in order to streamline the process of determining what needs to be assessed in each case. It could also be to see how ecological considerations could be front-loaded at the plan-making stage, to question whether planning authorities throughout the country could adopt a more consistent approach to screening planning applications and then engaging over the lifetime of developments, and also perhaps to look to protect distinctive UK species which the EU might have overlooked, such as adders and pine martens. And the Secretary of State announced a £5 million fund to establish a national natural capital and ecosystem assessment, which it's thought will be used to maintain a central database, which would hopefully avoid the need to establish an environmental baseline for each new proposal. The Secretary of State suggested that the government was committed to building back better and greener, and that it wanted to leave the environment in a better state than it had found it in. But this didn't come long after the Prime Minister's criticism of newt counting delays in the planning system, leading some to wonder whether actually the review might lead to weakened environmental protections. So although there's no immediate change, according to the government, now that the transition period has come to an end, the UK is free to chart a new course in its approach to the environment, and it remains to be seen really what that course will look like.
So this is our chance to think about what it should look like. And so Duncan and I are both going to give some thoughts about this. So if I kick off, I mean, to start with, I think we should assume that we're working within basically familiar structures, because after all, you know, the Trade and Cooperation Agreement essentially guarantees that environmental assessment will survive in its basic current structure, because there's a provision that environmental assessment procedures shall comprise, where appropriate and in accordance with the parties' laws, the determination of the scope of an environmental report and its preparation, the carrying out of public participation and consultations, taking into account of the environmental report and the results of the public participation and consultations in the consented project or adopted plan or programme. So that's a very familiar structure that you know, I think we should assume will continue to apply. So I was thinking, as we all have, about, well, what are the current downsides of environmental assessment processes, and what are the advantages? And we've heard a number of these already, and I'd sort of echo what Steve and Charlie have been saying in terms of downsides. Well, yes, it can be said to be slow, expensive, perhaps often overly formulaic, particularly in relation to SEA, perceived as controlled by the scheme promoter, undoubtedly, confusing for the public, intimidating, certainly. There are legal trip hazards. There's an unpredictable approach taken by authorities to screening and scoping, and historically a lack of subsequent checking of reality against predictions. So those could all be taken to be, I think, legitimate perceptions and criticisms of the system, but advantages of the system, as we've been talking about. It's undoubtedly a thorough process. It's science-based. Those legal trip hazards, are undoubtedly a discouragement against corners being cut. People joke about the lawyers involved in the process, but my experience is that, often, that is adding robustness and rigor to the work that is being carried out. The process also does mean that much more data enters the public domain than would otherwise be available for understanding and analysing what's actually happening and the implications of what's happening. So when we take all that, my own personal ideas for improvement, well, I think much more is possible, but, I err against, anything too radical. I think, first of all, certainly better guidance, or more detailed guidance on screening and scoping, which I find to be locally unpredictable. Routine promulgation of MHCLG screening directions, I think, would be really helpful, because they would sort of set the bar for different types of development in different circumstances. I've always said that guidance from government with just indicative word limits for most types of planning documents, actually, not just environmental assessments, would be really helpful, just to indicate that a document isn't going to be given more weight just because physically it has more weight. Less is sometimes more. Further moves towards digitization, absolutely, and there's a lot of good work that's being done already, so that the assessment, partly so the assessment doesn't just exist in numerous PDF chunks on the authority's planning portal, but can be interrogated properly and compared to equivalent findings elsewhere, but also so that we can build upon a growing resource. More radically, in terms of the perception that these processes are driven by the client and the client team, which I think is an unfair criticism given the professionalism of EIA consultants and their teams. But, in order to have a greater perception of independence, well, should a duty of care in some circumstances be extended to the authority as well as to the promoter client? Or maybe there should be a duty in the legislation in the same way as accountants signing off a company audit. Would that help? Proper monitoring of outcomes and publication of the results of that monitoring, we're moving towards that with amendments to processes, but more of that would certainly help. Local plan sustainability assessments, I think, are really need review. Certainly they need to be more focused, and I don't really know what the answer is, but we need to see assessments which are a quarter of the size of current assessments, but possibly with 4 times as much proper analysis would be my aspiration, and particularly for us to be able to get to grips with what is really meant by reasonable alternatives. How do we arrive at what reasonable alternatives are to policies which achieve the objectives of the plan, and what analysis is really needed that is going to help form the basis for the authority's decision making, and for people to understand the basis for the decisions and choices made. And then lastly, in terms of habitats regulations, I pause to say it, but should we look again at the screening constraints introduced by people over wind? Should we go back to the Mr. Justice Sullivan and Hart? It seemed to work for many years, where mitigation could be taken into account at the screening stage with HRA. And I think we also need to look at mechanisms which have been convenient, but like SANGs, suitable alternative natural green space, and question whether that could be, whether they are achieving the aims. So they were my thoughts. Duncan, do you want to take off from there, and what are your ideas?
Yeah, I mean, I think the question is that I think there's a lot of appetite for reform in this area. Steve, I think, was very right to caution that don't throw the baby out with the bathwater, because it is performing a useful function. And I think we also have to start by recognizing the constraints that Sophia and others have alluded to already, which is the Trade and Cooperation Agreement, which seeks to preserve current levels of environmental and climate protection from both the UK and the EU. And so far as it affects trade, that's probably quite an important qualification. And it also includes a commitment from both parties to the environmental assessment process, assessing effects from activities and programs that impact on the environment. So we have that constraint. We also have the international treaty constraints, which Sophia referred to, ESPU, particularly in the context of transboundary effects, with other countries, but also the Aarhus Convention, which has been referred to, not only public participation in environmental decision making, but access to environmental information, and importantly, access to environmental justice to challenge public decisions. And I think there obviously has to be a framework that fulfills all those things. Environmental assessment is it in its broadest sense, and it's here to stay. So yes, it can be improved, and I agree with virtually all you've said, Simon, in terms of what in practice would help to make that work better. But there is an opportunity to perhaps be a bit more radical. Before we do that, I think we have to take a step back and ask ourselves what we want environmental assessment to achieve. Is it just about looking at impacts, understanding the environmental consequences of plans and projects? Is it also about raising environmental awareness and environment and public participation, environmental decision making? I think unarguably yes. But should it also be a sustainability assurance tool? In other words, should it be trying to embed environmental and probably social, cultural and economic values into decision making? At the moment, I think you could probably say that we try to use environmental assessment to fulfill all those objectives. Whether it's succeeding or not is another question. I think as an impact assessment tool, as you've alluded to, Simon, it does work, but with a significant investment of cost and time. And if we're looking at, what can we do really to improve the process, we have to look at how we can strip out some of that cost and time. I think it's hard to argue as well that EIA and other environmental assessments haven't improved public awareness, and in fact awareness of developers and authorities of environmental issues. But I'm not sure it's working really as a means of public participation. We've alluded to the complexity and the volume of assessments. I think the result of that is it's not really properly understood as a process by the public. I also think the length of VAs and material gets in the way of public engagement. And let's all face it, in practice, we all know the technical summary, however well written, tends to be right at the end of the process and rushed. In other words, the most accessible document for the public is a rush job. It's not given its proper status, in my view. And I think it's no accident that as a result, we have plenty of after the event challenges, which the court have been critical of. In other words, raising EIA as a ground for legal challenge when it hasn't really been explored by that objector or campaigner at the application stage. I think if you look at it as a sustainability assurance tool, arguably it's helpful, but the price we're paying for that at the moment is that it, we're covering more than just the environment in its strictest terms. We're covering cultural issues, social issues, economic issues, all within the same framework. And there's a question mark whether that is right or not. But if it is right, then there are absolutely, I think, two key fundamental areas where it's not working as a sustainability assurance tool. That is the issue of alternatives, which you've referred to. There isn't really an adequate assessment of alternative options, partly because the law doesn't require you to do that. The question is, should it do? And we don't really do follow-up. In other words, we don't look at the real-world consequences of decisions that are taken, checking whether predicted impacts have had that outcome. So with all that in mind, and bearing in mind the constraints of the treaties and the Trade and Cooperation Agreement, I would like to suggest sort of three areas for more radical reform. The first is streamlining environmental assessments. I think in the UK we're very good at coordinating multiple environmental assessments rather than trying to wrap them into a single or related process. So, for example, a habitats regulations assessment is usually coordinated with but separate from environmental impact assessment, and strategic environmental assessment at plan level rarely ever has any relationship in practice with the project level environmental impact assessment. I think that's not only confusing for members of the public, but it's also inefficient. And a real benefit of taking a more integrated approach would be the ability, to assess impacts where they're best assessed, and to promote a better understanding of how decisions or assessments are linked to each other. For example, it's conceivable that, if it was well done, plan level SEA could shape and reduce the scope of project level EIA. So that's one idea. The other idea is perhaps a little bit more radical, is separating the technical and making it less contentious. So either move to a better independent quality assurance of the technical content of EIAs, or environmental assessments generally, which is undertaken as part of an application or plan making process, or have an entirely separate independent technical approval process for environmental assessments, possibly before decision making or public participation begins. If we did the latter, that would allow us to focus on outcomes and choices between outcomes rather than the process, and also perhaps help to build more consensus around the potential outcomes. And finally, borrowing a lot actually from work that I've seen done by the Policy Exchange and also the Institute of Environmental Management and Assessment, building a central digital database, having a set of or data sets for environmental baseline conditions and measured impacts, would be a huge step in the right direction in terms of reducing cost and time involved, because it should, if done successfully and comprehensively, reduce the time and cost involved in undertaking baseline surveys, because baseline data would be accessible on an open source basis. It may help with more meaningful assessment of alternatives, because people would have time and the data to help them do that. It would help to remove disputes about the quality and accuracy of data, potentially assisting with mitigation solutions, also assisting with post-decision monitoring. And it could help in the long term, I suspect, to develop environmental bottom lines, which we don't really look at all, really. In other words, what impacts are we not prepared to accept as an outcome? We don't really get to that point. We always make compromises or look for compensatory measures, but there may, in fact, particularly in the current climate, to that word, I'm using that word literally, there may be impacts that are unacceptable and should be unacceptable from a policy point of view.
Yeah, there's some really points there. Charlie.
Yeah, Simon, I just wanted to come back really on what you and Duncan were saying. It strikes me, listening to what both of you were saying, how important guidance is going to be, because the Commission guidance on SEA, EIA and habitat, it isn't really very useful. You can pick bits in it that work for everybody. So I think it seems to me that if the new regime was to have a provision for statutory guidance, which had to be taken into account, if, for example, in considering the adequacy of an ES, and perhaps had to be taken into account either expressly or by derivation by the courts, that would allow for a greater sort of nudge or steer to be given to the industry, greater than sort of the black letter terms of legislation could provide. And take 3 sort of points. I mean, in relation to word limits, I completely agree with you, Simon. I'm told, that I think it was the ES for the Channel Tunnel Rail Link was, a few, either a lever arch file or something comparable, where I know when I did pupillage at Landmark that the Crossrail ES took up, I think, at least 1, if not 2 rooms in its total, which isn't really serving the purpose of public participation at all. And I think if you have a word limit, which, or at least a recommended word limit, subject to exceptional circumstances and guidance, people would just make it work. Just as when David Holgate issued a word limit of 25 pages for skeleton arguments in the planning court, people just made more of an effort to keep to 25 pages rather than sprawling. And I think you could also have a style guide, or key headings to include, because the reality is, all of us who deal with the ESs, for example, you'll see chapters that just chuck in references to every piece of legislation under the sun. Well, that doesn't tell us anything. What we want to know is what the main impacts are going to be, not what a list of legislation and building regulations that relate to climate change. And also in relation to reasonable alternatives, how do you work out what should and shouldn't go in? Again, I think if the nudge was given to industry, people would be less defensive, because if in the absence of guidance, I think that's what's led people to have a sort of kitchen sink approach to environmental assessments as a sort of risk avoidance measure, to avoid people like you and me pouring all over them and bringing high court challenges. Whereas if you had this sort of guidance, it would give them cover to take a more focused approach.
Steve, do you have any views on
Yeah,
that?
I was just going to come back on that very point, but it's a good segue to pick up where Charlie finished. I mean, one of the issues, picking up for some of the comments and questions, actually quite interesting. There's reference to gold plating, to trying to avoid the risk, and people not wanting to take the risk of challenge. And in a way, that sort of highlights the fact that the process is being used not as originally intended to assess environmental impacts and whether it's sustainable development, but just to try and avoid the risk of somebody like your good selves challenging them. And it strikes me that, when you've got regulations which requires the developer to have competent experts, requires the local planning authority to have sufficient expertise, in which I'm talking about EIAs here, to assess it, it almost is setting up experts against experts to create a process which is about trying to de-risk the situation, rather than what the objective was what are the environmental impacts and what is this sustainable development, and are there alternatives? And it strikes me that one of the questions which perhaps one of you 3 might want to give an answer is the answer, as much as simplifying the system and making it more streamlined, but to de-risk it by narrowing the areas in which you might want to challenge it?
Ooh. You want to
That's
respond
again,
to
if you get a non-lawyer on the panel.
I mean, I think, to be honest, I think the courts have probably done that sufficiently already. I think you could probably bake that into the legislation and or the guidance so as to make it more obvious to practitioners who may not perhaps be fully aware of, for example, what the Court of Appeal decided in Plan B about the wide margin of appreciation. I mean, I was toying in my mind whether you could even, say that the ES only needs to look at the main environmental impacts or something like that, which might achieve. There's a danger then that you then end up with litigation as to what that means. I mean, we lawyers find a way of arguing over everything. So I think probably it's more a matter of codifying and baking in the existing principles that I discussed personally.
Yeah, there are recurring issues, aren't there? I mean, there's so much about cumulative effects, reasonable alternatives. The courts are very reluctant to delve into the detail of the adequacy of particular chapters of an ES, and yet somehow there's a perception, whether it's amongst some lawyers or some consultants, that there is that risk. I think it's the risk is rather different. I just want to go back to what you were saying, Charlie, about what what plans and programs SEA should really apply to, because comment was made by someone in the Q&A function. Of course, it's a bit ironic that possibly the biggest effects of any plan or program recently have been the changes to the General Permitted Development Order, but in the Rights Community Action litigation, the court, of course, held that the GPDO didn't set the framework for subsequent decisions, and it just shows the sort of slight
oddity. I mean, yes, it's odd, isn't it? No, I agree. I mean, my own view is that was legally quite correct, but it's strange, isn't it, that something which can have really far-reaching implications doesn't have to be assessed, whereas a neighbourhood plan might have to be. That does not, and the legislation, if it could iron out sort of oddities like that, that would be sensible. Although I suspect the government's going to want to iron them out in favour of deregulation rather than regulating things which aren't currently regulated.
Do we see, so picking up on some of the comments from the panel, do we think there's an opportunity to really bring together SEA, EIA, habitats into a more understandable, cohesive structure, really part of the planning process, and to try to make sure that we don't have unnecessary duplication between the plan making stage and the development consent stage, which would fit so well with the discussion about, for example, growth areas in the new world of planning for the future.
So, I mean, well, I think the answer to that is yes. I mean, I said about the white paper that the government should take a step back and ask themselves, what is the purpose of planning? And then design a planning system that delivers that purpose. And in a way, there's an opportunity to do exactly the same with the SEA, EIA, and habitats regimes. What is the purpose of those regimes? And then set about designing a revised regime which meets that purpose.
Yeah.
And I think one of the things I think the planning reforms do require is that streamlined process that I was referring to earlier, particularly if you're going to start having site allocations with consenting consequences. We need something that can adapt to assessing that kind of situation where actually you're giving consent for a project, not just making a plan.
I think what it does show is that the new legislation is, in a sense, by definition, going to have to be relatively radical if the planning for the future white paper proposals come forward, because at least in relation to growth areas, SEA and EIA are going to have to merge to some degree or other, and so that, in one sense, I think that's quite good, because it means that there is scope for something fairly fundamentally different from the basics. Might still be there, but there may well be some scope, some fairly fundamentally different reforms, which hopefully done right will be for the better.
Yeah, well, I found that fascinating. We've come very quickly to the end of our hour. As I said at the beginning, I really hope that people will, there'll be an email that will go out as usual tomorrow with a link to the recording of this session, so that you can homeschool your children in the subject of environmental assessment or do something with it. But you can take the opportunity to respond to the email, maybe with some thoughts about how you think the system should be improved. And this may be over ambitious, but I think we could then look to try to collate some of that thinking and maybe share it with civil servants, because I have no idea what the latest is on the consultation that Sophia was referring to, where which was promised in the autumn. It may land very quickly, but if there's an opportunity for us to make some constructive suggestions at this point, I hope that they will be gratefully received. So anyway, thanks everyone for listening. Thank you to the panel for doing your stuff so well. I hope Charlie gets time to take down his Christmas tree before too long. And no doubt we'll be running another session once we see what the government actually proposes. But thank you again, and have a good evening.
Thank you. Good night.